Good morning, everybody. I'm going to follow up with another article by my friend Justin McPhail that was written January 19th, 2026. Constitutional Framework, Judicial Proceeding or Family. Let me read that again. Are the oldest and most precious of all our rights routinely violated in courtrooms that appear legitimate for the purpose, but are in reality not judicial proceedings. Okay? Here's his article. See that horrible bench? Ugh. But I will have to say there are good judges out there. I've had 3 of them, and like I had said before, one of them was really hot, but it was not the president judge. Anyway, moving right along. Justin writes what it means to be judicial. What qualifies as true judicial proceeding under the 14th Amendment? Learn the minimum elements required before any state may infringe parental and family rights: jurisdiction, burden, evidence, findings, and meaningful review. I'm going to add to that. When I was in federal court, they kept saying I was in the wrong jurisdiction. Hello. The state court was kitty corner to the federal courthouse, so I would say I'm in the right jurisdiction, which they finally agreed to, but that took weeks and weeks. So I think they were trying to scare me off from continuing with this federal case, but that's done and over with. Going back to the article, key takeaway in plain English. Before the government can interfere with your family, the process must be truly judicial. The state must show up, prove harm, present evidence, and the court must make findings before issuing orders. If force came first, it wasn't judicial and it wasn't lawful. Okay? The constitutional baseline, why a proceeding must be judicial to restrict fundamental rights, okay? Parents' rights as a fundamental liberty. The Supreme Court has long held that parents possess a fundamental liberty interest in the care, custody, and control of their children in Troxel versus Granville. And that's very near and dear to all our hearts. Okay? The court reaffirmed that a fit parent's decision must receive special weight under the 14th Amendment. This recognition did not create a new right. It is acknowledged an ancient one. And for those of you that have just joined, I am reading an article by Justin McPhail on Substack that was written on January 19th, 2026. Okay. Now, due process as the gatekeeper. When the state seeks to burden or sever this relationship, due process is not optional. In Stanley versus Illinois, the court rejected presumptions of unfitness and required an individualized hearing before the state could interfere. In Santosky versus Kramer, the court required clear and convincing evidence before terminating parental rights. The message is consistent. Law must come before force. Okay? Minimum elements of a judicial proceeding, the bare minimum test. Number 1, jurisdiction established on the record. Jurisdiction is never presumed. The state must identify its authority, statutory and constitutional, and justify intrusion into family life before compelling compliance. If the state never appears to claim authority, jurisdiction never attaches. Very important, okay? Number 2, a defined controversy. Specific provable harm. Courts resolve real disputes. Who did what to whom and how it violates the law. Vague concerns or a freestanding best interest mantra Do not create justiciable case without proof. Troxel versus Granville warned against replacing constitutional protections with preference, okay? Okay, proper burden of proof. The state bears it. Parents are presumed fit. Children are presumed entitled to their parents. The party seeking to restrict that relationship, the state must carry the burden before coercive orders are issued. And I'll add to that. In the lower courts, the judge just ruled at his discretion and just did whatever he wanted. And, I think a lot of people know my case. If you don't know my case, it's all in here. Dismantling family court corruption, why taking the kids was not enough, because the case was so bad, a book had to be written. Anyway, going back to Justin's article, evidence presented openly and tested. Judicial decisions rest on the record, testimony, exhibits, cross-examination, untested reports, private interviews, and off-record impressions are administrative shortcuts, not adjudication. I will add to that. And I've said before, and I think we all know, that these judges are not looking at evidence. And evidence is suppressed, which means someone's hiding the evidence from either the prosecutor or the judge or the opposing counsel or however. But there's a lot of people responsible for doing that. And it could be the judge, or it could be the clerk, or it could be a family member working within the courthouse assisting in suppressing evidence, okay? And that's kind of what happened in my case. Probably everybody else's too. Okay. All right. Findings before orders, adjudication before disposition. Sequence matters. Courts must decide whether a legal violation occurred before deciding what to do about it, using testing, evaluations, or separation to find out if someone is unfit flips due process on its head. Thank you, Justin, for writing that. 6, writing findings tied to standards. A judicial act must be explainable. Written findings must connect facts to governing legal standards. If no one can point to where the court explained itself, judicial reasoning did not occur. I really like that. So a judicial act must be explainable. I'm going to say it again. Written findings must connect facts to governing legal standards. If no one can point to where the court explained itself, judicial reasoning did not occur. Yeah, isn't that cool? Number 7, meaningful review. In parentheses, real appeal, not theoretical. Judicial power is answerable. If appeal illusory, goodness gracious, and constitutional claims never reach the merits, a core judicial safeguard is missing. Okay, so judicial power is answerable. If appeals are illusory and constitutional claims never reach the merits, a core judicial safeguard is missing. Isn't it always? I'll add that. Law before force. What this looks like in family courts. Sequence that respects rights. The state appears and claims lawful authority. Specific allegations are noticed. Evidence is presented and contested. I'll add to that. Or suppressed. The court makes findings of fact and applies the law. And only then disposition. Okay? Red flags, tests, evaluations, restrictions before findings. Drug tests, psychological evaluations, or restricted parenting time ordered before findings of unfitness or danger signal force before law. Santosky versus Kramer underscores that heightened proof is required before severe consequences. Investigative tools cannot replace proof. So, again, this also is your evidence. And it has to be acknowledged. That's my input. Your evidence has to be acknowledged. Even if the judge looks at it and wants to throw it out, it still has to be on the record. I'm not a lawyer. I cannot give, legal advice, but my opinion is that just get it on the record. Try your best. Reality check. Plain English audit any parent can use. Number 1, did the state actually appear and claim authority? Not the other parent, the state. If no government actor before the burden, ask where jurisdiction came from. Number 2, were you punished before being found unfit? Orders to test, evaluate, or separate first with promises to sort out later are backwards. Okay. And I'm going to add to that too. They've got to still look at evidence. Evidence. And you've got these orders to test, evaluate, or separate first with promises to sort it out later. Oh yeah, don't go there. You've got to sort it out now. That's my opinion. Number 3, orders before facts, findings before orders. Real courts find facts, apply law, then order. Reverse order equals non-judicial. Okay? I'll add to that. These family courtrooms are illegitimate. Okay? Because the Constitution is not followed. We live in a constitutional republic, and we should be handling it as such. Number 5, did jail or the threat of jail enforce compliance or silence you? Okay, civil confinement is lawful only if it can coerce compliance with a clear, achievable order. If it made compliance possible, it failed its only lawful purpose. Okay, so let me add to that. Threats of jail. I was threatened with jail multiple times. And they're doing this to a lot of parents. Okay, I was annoying him. Because, when a parent tells the truth, it annoys the judge. And then he threatens you with jail. Unbelievable. But again, we're talking about a family courtroom where it's an illegitimate courtroom. Okay? Number 6, could you realistically appeal if no court reached constitutional arguments on the merits? Meaningful review may have been absent. Okay. The staircase of jurisdiction, in parentheses, built, not presumed. The step-by-step build is authority, allegation, burden, evidence, findings, disposition. Okay? Skip a step, lose the staircase. Courts cannot leap to the top and call it jurisdiction, nor use coercion to create the authority they claim. If testing or separation is used to build jurisdiction, the process isn't judicial, it's a command. Okay? So the courts cannot leap to the top and call it jurisdiction like they did in my federal case. They just went after the jurisdiction first, okay? And that was a big no-no. They eventually acknowledged it. Nor use coercion to create the authority they claim. If testing or separation is used to build jurisdiction, the process isn't judicial, it's command. When jurisdiction is missing, a judge becomes a man or woman. Okay. Why authority attaches to lawful process, not to a robe, otherwise known as a Halloween costume. Judicial authority flows from lawful jurisdiction, not office. When a judge acts in the total absence are nullities. Stanley rejected administrative shortcuts and demanded individualized adjudication. Okay. Frequently asked questions for non-lawyers. What if a judge ordered a drug test just to be safe? Like always. Safety cannot replace process. Tests ordered before findings flip due process. Number 2, isn't best interest of the child enough by itself? No, Troxel versus Granville makes it clear that the best interest alone cannot override a fit parent's rights without proof. Number 3, do I get a hearing before the state can take my child? Yes, due process requires an opportunity to be heard, with the state carrying the burden. Stanley forbids presumptions, okay? Number 4, what burden of proof applies in termination cases? Clear and convincing evidence per Santosky versus Kramer. Can a court use evaluations to decide if I'm unfit? Evaluations may inform disposition after findings. They cannot substitute for adjudication. Okay? Number 6, what if I couldn't get an appeal on the merits? If you're wondering what that means, appeal on the merits, if your case has merits, it means that you have evidence proving what happened actually happened. It's the merit of the case. Am I explaining that good enough, I hope? Meaningful review is part of judicial power. If constitutional claims never reached the merits, a critical safeguard was missing. Okay? I'm going to read that again. Meaningful review is part of judicial power. If constitutional claims never reached the merits, a critical safeguard is missing, okay? Now, here's a quick reference table. Judicial versus non-judicial signals. Feature, judicial proceeding, non-judicial signal, state, appearance, government, bears burden, private dispute masquerades as a state action, sequence adjudication. Disposition orders first, facts later. Proof, evidence, tested on record reports, impressions, off-record findings, written, tied to standards, none or vague coercion after findings, before findings, review, real appellate path appeals denied on merits. Okay. Justin wrote a long article. External resources and further reading. Troxel versus Granville. This is like totally sacred, okay? Granville. Parental liberty. Special weight to fit parents. I also think Troxel versus Granville would be a nice name for a horse. Your thoughts? Okay, then you've got Stanley versus Illinois. No presumption of unfitness. Hearing required. Then you've got Santosky versus Kramer. Clear and convincing evidence for termination. Okay, then juvenile practice materials emphasizing adjudication before disposition. Here's a conclusion. Justin writes, if it wasn't judicial, it wasn't lawful. To lawfully interfere with a fundamental right, the proceeding must be judicial in character. Jurisdiction proven, burden on the state, evidence tested, findings before orders, and meaningful review. If courts used coercion to discover facts, required parents to prove their own fitness, or never explain themselves in writing, law was replaced by force. And where law is missing, there is no court, only orders without authority. That's awesome. Okay, so I'll just repeat part of that. If courts use coercion to discover facts, required parents to prove their own fitness or never explain themselves in writing, law was replaced by force. Oh, hello. Okay, thank you. Thank you. Orthography, thank you. Okay. And where law is missing, there is no court. Only orders without authority. Okay, so the parent's judicial proceeding checklist. Okay, so if you answer no to any of these, the process was not judicial. The purpose. This checklist lets a non-lawyer audit whether the state lawfully acquired authority before interfering with family or parental rights. A, jurisdiction and state appearance. Did the state actually appear as the state? Not just the other parent, a government actor claiming authority. Okay, so that question is, did the state actually appear as the state? Number 2, did the state explain on record why it had authority to intervene in your family? Number 3, was jurisdiction established before you were ordered to do anything at all? Like appear in court, do tests, evaluate, restrict contact. Okay, here's B. Defined allegations, not concerns, okay? Were you told specifically and in writing what you allegedly did wrong? Did the allegation describe real, provable harm or imminent danger, not vague fears or preferences? Okay, was the issue framed as a legal violation, not a personality dispute or parenting style disagreement? Like always, right? This is an excellent article by Justin McPhail. You can find him on Substack. And I will transfer all of this to my YouTube channel, Slam the Gavel, okay? And I'm also on all major platforms, but you'll find this one on the YouTube, Slam the Gavel. Burden of proof. Did the state carry the burden of proof? In parentheses, you were not required to prove your own fitness. Okay, was the burden explained, preponderance, clear and convincing, etc.? Was that burden met before restrictions or punishments were imposed? Oh yeah, that was kind of done in my case. The burden kind of was not allowed to be met because they imposed punishments first. That's my case. Like always in family court, which evaluations tested or just accepted. I'll add to that. By these third-party parasites, these guardian ad litems that just come up with things in their head. You know, they just, will listen to one side, just give a one-sided, review of your family because, they have all this power. And they're third-party parasites, okay? Did the court make findings of fact before issuing orders? Okay, written findings. Did the court issue written findings explaining what facts it found and why they met the legal standard? Can someone read the order and understand exactly how the court reached its decision? Okay, disposition, orders, and enforcement. Were orders issued only after adjudication, not to find out if allegations were true? Were tests, evaluations, or restrictions used to enforce findings, not to create them? If jail was threatened or imposed, was compliance actually possible? Okay, just to let everybody know, they always threaten jail to everybody. Okay. Where can you find this information? You can find this on Substack, Justin McPhail, McPhail. Okay, he's been on my podcast, Slam the Gavel. He's been on twice. Did a fantastic interview. He is a force to be reckoned with. Okay. G, meaningful review. Did you have a real opportunity to appeal on the merits? Did an appellate court actually address your constitutional arguments? I'll add to that. They didn't, at least on my case. They just dismissed it. And that's what they generally do to everybody else. I'm sorry to say. Was review practical or merely theoretical? I don't know what these judges are thinking. I have no idea. What I can say about federal court, I'll just add this real quick because this article, I'm almost done. But in federal court, the opposing attorney hauled me into a boardroom and said, look, I know both these judges in the federal court. I'm going to get this case dismissed. And that's pretty much how it's going to go. So I put that into an affidavit like I talked about yesterday. And you can find that on YouTube, Slam the Gavel, because affidavits, in my opinion, are gold and they are evidence. And I submitted that to all parties. And yes, there was some disciplinary action. Pays to complain. I know people say, oh, complaining doesn't get you anywhere. Oh, yes, it does. Okay, scorecard. Okay. All or nearly all yes. If you answered yes, the proceeding likely had judicial character. Multiple no's, if you answered a bunch of no's, the process was administrative or coercive, not judicial. Force before findings. Jurisdiction likely never attached. The bottom line, Justin writes, if the process relied on coercion to discover facts, presumed unfitness, or punished you before adjudication, it failed the constitutional test. That's what happened to me. I'm going to read it again. The bottom line, if the process relied on coercion to discover facts, presumed unfitness, or punished you before adjudication, it failed the constitutional test. Okay, so Justin writes, how to use this checklist practically. Before a hearing, bring it. Ask where each requirement appears in the record. During the proceedings, object to steps taken out of order. Adjudication must precede disposition. Afterward, use it to frame motions, appeals, or civil rights claims. Okay, so we're not lawyers and we're not giving legal advice, but where he says before a hearing, bring the checklist and ask where each requirement appears in the record. Now, see how that goes, and hopefully you have a decent judge that will listen to you and will give you a chance. And I think these judges should really be listening wholeheartedly to the parent, because this is very important. This involves our family. And I'll add to that, I've said this on my podcast, Slam the Gavel on YouTube, that these judges, in my opinion, if they've been rotting on the family court bench longer than 23 plus years, I think they should have psychological evaluation. I think they should be drug tested randomly. I think they should have lie detector tests to see where monies and their judge campaign funds or where they're coming from, right? So, these are things that I worry about with these judges being on the bench that long, because it's just not good for anybody if they're burned out, okay? And I had to deal with a judge that was on the bench for 23 years, okay? I don't think anyone liked her. A lot of us didn't, but anyway, she just had it out for everybody, and glad she's off the bench. But anyway, someone on the bench that long must have a psychological evaluation. If you think about it, it's like, okay, so even with doctors and nurses and people taking care of other people, they have to keep up with their, I guess they call them CLEs. We always had to take yearly exams just to make sure we're up to date with medical practices and things like that. And some attorneys feel they don't have to do that, but we have to do that because we're taking care of people and their families. Okay? So the judges should be doing this. And if they're not having a great time on the bench in family court, I don't know. If someone might know the answer to this is, when you go into these courtrooms, take a notepad. This is what I did. What I did was I took a notepad in with me, and as soon as the opposing counsel was talking or blathering or babbling and creating a false narrative, because that's what he did best, and I would just write down all his lies, for lack of a better word. And so then when it was my time to talk, I could say, this attorney misspoke. Nice way to say he lied. So we have to, say, oh, they misspoke. Why are we being so nice? This is not a nice courtroom, okay? This is an illegitimate courtroom where it's like the Wild West, okay? So I couldn't understand the word misspoke. Why do I have to say that? Lied. Why can't we say they just came out and lied? Okay, I don't know. So in my court case, in that hideous courtroom from hell, for some reason, I don't know if this works with everybody else's case, let me know, but the opposing attorney gets to talk first. I don't know why. I wish I could have opened up and talked first. And this is how this whole big ball of wax unraveled into hell. Because when I walked into family court on March 2nd, 2015, they first opened out. He created the silver bullet saying she's mentally ill and she's alienating the father. How does a nurse of 23 years go batshit crazy overnight? It doesn't happen. So they have to create their false narrative that you're crazy. And this happens to guys too. They've called guys crazy, okay? I've talked to well over 800 parents. I still have parents calling me every day. The interviews you can find on Slam the Gavel podcast on YouTube. So it's almost like the same story but different city and state. This corruption is just sad. And our kids are paying the price. Sammy, if you assert your rights, you're automatically crazy. Right, because I was told that they call you crazy when you know what you're doing and when you're knowing how to respond in the court system. So if you know the laws and you know what you're doing, they call you crazy. So be prepared for that. And what else did they do to me? They just ran the show. It was a 3-ring circus. I think a lot of people may know my story, and I don't want to bore you, but the judge was running it like a 3-ring circus. So when they automatically took my kids away March 2nd of 2015, based on also the false allegations of Office of Children and Youth here in Pennsylvania, okay? So they just let these caseworkers talk and blather on and lie, okay? And they're on the stand, where she told the judge she was promoted, when in fact, I know for a fact she was demoted because I talked to the head of the caseworkers there and said, she's not fit to be around people. So I said, so you promoted her, right? And he said, no, I wouldn't call it that. So now she had a desk job and she couldn't terrorize parents anymore. You're welcome. But anyway, in my case, up there perjuring, and we all know they do it because it's been done to you and it's been done to so many parents. And I hope we all understand this and know that whenever CPS is on the stand, the judge is just going to go with what they're saying. So he or she doesn't have to make the decision and gets out of their little immunity thing and puts it, the burden is all on the CPS caseworker, right? Okay, so It was fraud, yes, Sammy. It was fraud, continuous fraud. But when you see this happening and you're watching this idiot, obese caseworker who can't even fix their hair before court tell lies on you and do a one-sided interview just with the ex and his wife who enjoys her job in the courthouse, you don't have a prayer, and correct, they lie on the stand. And now that you say that, I will add that if you ever watch the movie The Judge, it has Robert Downey Jr. in it, and the best part of that movie is he takes his shirt off. Okay, but anyway, he played a litigator, and his father was the judge. And I won't tell you the whole premise of the movie because I don't want to ruin it for you, but the judge, his father, got into a criminal act, okay? So he had to litigate his father out of this mess. And he told his father, come on, Dad, come on. Everybody lies on the witness stand. Go watch the movie. Honestly, God, it's a good movie. Okay, so in the cast of The Judge, if you're wondering, Leighton Meester, Robert Duvall, Robert Downey Jr., Vera Farmiga, I just love her, Sarah Lancaster, Billy Bob Thornton, and he played the prosecutor. He was really good. I just love him too. He's one of my favorite actors. There's also Jeremy Strong. I love him. He played the brother. You got to watch this movie. This was really super, super good. It came out in 2014, in case you're wondering. Okay, so, and I really didn't want to see this movie, but Brad made me watch it. Brad is in the book. So I know how to leave you with all of this because I know this is just a deep topic. And what I read to you from Justin McPhail on Substack was pretty deep. And I will transfer all of this onto my YouTube Slam the Gavel. And I totally appreciate you all for supporting me and watching me and supporting my channel, YouTube Slam the Gavel. And I will be bringing forth more hosts as well to come on and speak. And we're just educating because we all have to educate everyone so we can teach people what happens in family court with the dynamics of CPS and what we can do to help stop this mess, okay? So to stop the mess, and this is my opinion, I'll leave you with that. Talk to young people, okay? People in their 20s and 30s, people that are probably maybe getting married, whatever. But talk to them and, find out, hey, do you have a prenup? What do you think? What happens if this happens? I did talk to a young fellow at Sam's Club. I'll say it again because I think I mentioned it yesterday. He said he would trust the process of everything. And it's like, no, don't trust the process. Please don't trust the process. But he was shocked when I told him to get a prenup because this could happen. I mean, you could be in a great marriage, right? And what if, God forbid, you're in a head-on collision and you both live? And I was explaining this to him, what if? And what if one of you have a head injury? And head injuries, they're vague. They can manifest in other things. I'm not a physician. I'm not giving medical advice either. But I'm just saying. I said, what if that person who you plan to marry and love and have kids with comes out of this accident with like a different person? And what if they decide they want to move back with mom and dad and take the kids away from you? I told him, I'm just giving you a scenario, whether, I hope to God that never happens, but it has to be in a prenup that if this doesn't work out, we will share the kids, okay, provided there's no criminal abuse happening, ABUZE happening, okay? So I know for a fact, because I co-parented for 10 years, that the kids were okay. And they were fine going back and forth. I think we did like 5 days on, 5 days off. It was like no big deal. We shared the holidays. And everyone was okay with that, to my knowledge. The kids never said, oh, we hate this. No one ever said that, because they got to see, right, Sammy, yes, settle your private affairs outside of court. God, I hope you can. You know, because this is what we did for 10 years. It can be done. But then he remarried someone who worked in the courthouse, and that should be in the prenup as well. If there is a divorce, yes, we share the kids, we share the holidays, and there's no interference and no one chirping in your ear saying, oh, no, you know, you should be doing this. You should be doing that. Keep these people at a distance. No, we're running it fine. Just leave us alone. Okay? And it has to be put in there because at some point people are going to remarry. This is what people do. But put in the prenup, again, I'm not a lawyer. I can't give legal advice. But put that in there as well. Whoever you marry does not interfere in the co-parent relationship you have with your kids. Okay? That I wish was in the divorce settlement that I signed with Seth. Seth is in the book. Okay. So I'm going to leave you with that. My third volume of Raised by These Wolves will be coming out February 5th. So in 2 days, I'm really excited. It'll be coming out on Amazon. Okay, and that has parent stories, and this is great because we have to learn from these parents. We have to learn how this happened, how they got into these situations, what they did to get themselves out of these situations, okay? So it's all out there, and I hope you all have a good day. And it's snowing a little bit here. We're all freezing. It's probably like 15 degrees. So gotta love you and leave you. And I will check back with you with another vlog tomorrow. And talk to you all soon. Thank you for everybody. You too have a great day, Sammy. You too have a great day, Dawn. Thank you so very, very much for your support. Okay. Have a great day. Stay warm. Bye.